Today we're going to be going through voluntary manslaughter. This falls under non-fatal offences in OCR A Level Law, and we're going to be looking at loss of control and diminished responsibility, which are the two types of voluntary manslaughter. But first, just a quick tip from me. So by the end of this video, you will know all the AO1 for voluntary manslaughter and how to distinguish between loss of control and diminished responsibility in an exam. So it is crucial to know all the AO1 for a 20-mark question in order to get the further AO2 marks. This is because the AO1 marks add up to 8 marks, which is all the content we're going to be going through, and it's a base for the application, which is AO2. So let's start off with the definition of voluntary manslaughter. So voluntary manslaughter is a partial defence for murder in order to lower a murder charge. So if we look at it on a hierarchy, murder comes first, and under it comes manslaughter, and there are two types, which is voluntary and involuntary, but today we're looking at voluntary. So it can be used as a defence for a defendant which is provoked or mentally ill, and this is for voluntary manslaughter. And there are two types that you need to know. These are loss of control and diminished responsibility. So all elements have to be proved for the partial defence to go through, and then the sentence of murder can be reduced based on the situation. So we're going to start off with loss of control. So we always start off with the definition of whatever we're talking about in an exam. It helps you to understand what you're talking about, and then it just leads to a chain of thoughts. So let's define loss of control. So this is a defence governed by Section 54 and 55 of the Crowners and Justice Act 2009. It's a partial defence to murder, which we already discussed. And to successfully use this defence, the defendant must show that they lost self-control, that there was a qualifying trigger for that loss of control, and that a person of the same sex and age with a normal degree of tolerance and self-restraint would have acted the same in that circumstance. So all these elements have to be proved, and that's the definition of loss of control, and we're going to be going through the steps. So the next one would be there was a loss of self-control. So the defendant must have lost self-control, meaning that they were unable to maintain their normal powers of reasoning. What this means is that the defendant couldn't control themselves anymore, and anything that they did wasn't voluntary anymore. The loss doesn't have to be sudden, but if there is a delay between the trigger and the killing, this may cast doubt for the jury and the courts on whether it was a loss of control or not. A good case for this is R.V. Jewell, and the court held that the defendant had not lost control because his actions were planned and deliberate, and therefore the defence was not available. So they tried to use loss of control as a defence, but the defendant had not lost control because it was all planned, and this does not fall under the categories of loss of self-control. Next, there was a qualifying trigger. This comes under Section 55 of the Act and must be shown, and there are two possible triggers that the defendant can have. The first is a fear of serious violence against the defendant or another identified person. This was seen in R.V. Ward, where the defendant killed after fearing further attacks on his brother. So there has to be a fear of serious violence against the defendant or someone that's identified. The second is where things said or done were extremely grave and caused a justifiable sense of being seriously wronged. Now, this is seen in RVZBD, where the defence failed because the circumstance did not meet this standard. So in this case, the thing that was said or done wasn't extremely grave, and it didn't cause a justifiable sense of being seriously wronged. So this still falls under there was a qualifying trigger, but we're just going to go through what does not qualify as a trigger, because this is really important to know, because you can get it mixed up and it's not good to get it mixed up. So sexual infidelity, according to Section 55, this does not count as a qualifying trigger. This was seen in R.V. Clinton, where the Court of Appeal ruled that while infidelity alone is not enough, it can be considered alongside other factors. In this case, it was depression. Loss of control did go through because there were other factors alongside something that wouldn't be considered a trigger. So 2, if it was done out of a desire for revenge. as stated in section 54. This just ensures that people who act in a calculated or people that retaliate don't get the defense because it wouldn't be fair. So next, the person of the same age or sex would do the same. So this is an objective element under section 54 and it requires an objective test. So would a person of the defendant's age and sex with the normal tolerance and self-restraint have reacted the same way? So what the jury would do in this situation is look at someone the same age, the same gender, and they would ask themselves if someone would react the same in that situation. Sometimes it's really obvious, sometimes it's not, and this is why we have a jury. So personal traits like bad temper or unusual beliefs are irrelevant. So if someone has a bad temper but it's not medically considered, or they have beliefs that are just not relevant, this just doesn't go towards this consideration. So in R.V. Mohammed, the defence failed because a reasonable person would not have reacted the same as the defendant did. So we've just gone over loss of control. That's all you need to know for the AO1, which is all your 8 marks for an essay 20-mark question. And next we're going to go and look at diminished responsibility. So as always, we start off with the definition. So firstly, the law recognises that in some cases, a person who kills may have been suffering from a mental condition that impaired their ability to think or act normally. Again, a partial defence for murder, and it's seen in Section 2 of the Homicide Act 1957 and amended by Section 52 of Croners and Justice Act 2009. So basically what it means is that the person that did the act couldn't think properly and therefore their sentence can be reduced. So next is abnormality of mental functioning. So the defendant has to be suffering from an abnormality of mental functioning. So this is a legal term, not a medical diagnosis, and it is defined in R.V. Bryan as a state of mind so different from that of ordinary human beings that the reasonable person would term it abnormal. So it's something really, really not normal and something any ordinary person would see as not normal. And in this case of R.V. Bryan, the defendant was a psychopath, and the courts decided that this amounted to an abnormality of mental functioning, and this reduced his sentence. So, this abnormality has to arise from a medical condition. This includes both physical and psychological conditions, for example, autism or personality disorders. There's much more that count, and you can have a look yourself. But normally we would be able to tell from a scenario what counts and what doesn't, because a physical or psychological condition, if it's identified in the scenario, we will know straight away if it falls under this category. So the courts may rely on medical evidence to determine this, and this was seen in R.V. Sears. The defendant was suffering from chronic depression, and the courts accepted this and recognised it as a medical condition. Next is that abnormality must have substantially impaired mental responsibility. What this means is basically that the abnormality caused the defendant to not be able to think properly, causing them to be impaired mentally. And one of these 3 have to be impaired, and that's understanding the nature of their conduct, forming a rational judgment, or exercising self-control. This was seen in R.V. Gold's. Supreme Courts clarified that substantial means more than trivial but not necessarily total. So next, there has to be a link between the abnormality and the killing. So there must be a causal link. If there's no link, we cannot draw the conclusion that the defendant's condition caused the killing. Otherwise, it just wouldn't be fair. So there has to be a link between the two, and the abnormality must provide a significant explanation for the defendant's conduct. It doesn't have to be the only cause, but it has to be a key factor. In R.V. Deichmann, the defendant was both drunk and suffering from an adjustment disorder, and the courts reduced his sentence. And it is important to note that intoxication alone isn't enough for diminished responsibility unless the defendant suffers from a medical condition relating to the substance abuse. This was confirmed in R.V. Wood, where the defendant had an alcohol dependency that was medically recognised, reducing his charge from murder to manslaughter. So The defendant's scenario in a question have to relate to the steps that we just discussed. However, how do you know the difference between the two? So, how do we distinguish loss of control and diminished responsibility? So, we have to look at the cause of the killing. So, if it follows an argument, fear, or provocation, it's loss of control. Or if it follows a mental disorder or a medical condition, it's diminished responsibility. Much more simple than you think. And when you learn it and you practice it, it's much more easier to understand. You just really have to practice and it becomes much more easier. So that's it for today's video. Thank you for watching. Please like and subscribe. And also let me know if you have any video ideas that would help, like going through exam questions. I'd be happy to take any recommendations. So just let me know and I'll be happy to help.